Okay, hey AP Gov, here we go. This is the first lecture in the last unit of the year. It's Civil Rights and Civil Libs. The notes and the agenda are on the website, so hopefully you got that. Alright, so we'll start with Civil Rights and Civil Libs. Essentially what we have is your liberties are your basic freedoms, such as practicing religion, freedom of speech, freedom of the press, freedom of assembly, and then you have something, your civil rights, which rights generally protect you against discriminatory or tyrannical treatment by a government, state government, national government, city government. Now, your civil liberties are generally protected by the Bill of Rights, the first 10 amendments, in simplistic terms. And then your civil rights are protected by the due process clauses of the 5th and the 14th. And we'll get into due process a little bit more in depth later, but due process is essentially, if they are going to take away some of your natural rights, they have to do it in a fundamentally fair way. The procedure in which they do that has to be fair. And we'll get into that later, but both the 5th and the 14th Amendments have due process clauses. All right? And generally, like your notes say, the Constitution, the Bill of Rights, the states, legislation, court decisions, all of these are designed to ideally protect your natural rights or your civil rights and your civil liberties. However, you have to apply something called the balancing test. And the balancing test kind of balances freedom versus order. As we started the whole year with, absolute freedom is the state of nature. And what some see as the problem in the state of nature is there's a bit of chaos. And so we sign a social contract, and the idea is government provides the order, and you get to enjoy more of your rights and liberties in this kind of orderly society. Now, there's a constant balance between freedom and order. And that's never going to be a perfect kind of definition, and I think a lot of people in our society have varying differences in their definition of that right balance between freedom versus order. So you should expect a good another 200-300 years of decisions that are constantly defining the appropriate balancing test of freedom versus order. All right? Always looking for that Goldilocks, just the right amount of freedom and order. All right. So the balancing test. Now, when we get into your natural rights and your natural liberties, the Bill of Rights, the first 10 amendments in which the Anti-Federalists insisted upon getting the Constitution amended to have these first 10 amendments because they felt that the outline of the Articles 1 through 7 did not limit or define the federal government's power enough. And so the first 10 amendments were essentially designed originally to protect you against the national government. Most people believe that it was that strong, distant national government, kind of like the British monarchy across the ocean, strong and distant, in which people weren't necessarily closely represented. That level of government would impose, tyrannical measures or limit your natural rights or limit your natural liberties. And so they didn't really think that the state governments would violate your natural rights because people had a closer relationship and they could right the wrongs of a state government through legislation, through elections, through state courts, that kind of thing. And so we get Barron versus Baltimore, which is this is a court case heavy unit, and do your best. We'll play around with these and try to figure them out. But Barron v. Baltimore was 1833, and essentially Barron felt that the city of Baltimore had violated his natural rights that were protected in the first 10 amendments. And what ends up happening is he gets into the court, he has standing, all that kind of stuff, and essentially what the government does in 1833 is they say that the Bill of Rights does not apply to the actions of state governments. State governments are responsible themselves for protecting, defending, defining the balancing test. And so Barron goes away. In 1833, the court rules in favor of the states, saying they can define, or basically 1833 in Barron v. Baltimore, the Supreme Court says the Bill of Rights only applies to actions of the federal government and not actions of the state governments. And now let's fast forward to the 14th Amendment. The 14th Amendment essentially says that no state shall deny any citizen life, liberty, or property without due process of law. And the key is, the Fifth Amendment had a due process clause, but that protected you against the federal government. The 14th Amendment changes, because this is part of the Civil War amendments, and what happens is it says no state shall. And so that was designed originally to allow the federal government to get involved in state issues. It's one of many things that the 14th Amendment did. And so now what we have is a different constitution than you had in 1833 with Barron v. Baltimore. By 1925, in a case called Gitlow v. New York, we have the 14th Amendment's due process clause. And essentially what Gitlow v. New York said is that your natural rights are protected not only against, or protected by the national government, but also the state governments. And so what happened is the 14th Amendment incorporated one element of the Bill of Rights to the states. Now, what incorporation means is just applied. The 14th Amendment's due process clause allowed the Supreme Court to say in Gitlow v. New York that it's the First Amendment's free speech clause applies to the states. So Gitlow felt that his freedom of speech rights had been violated by the state of New York, and while the Supreme Court disagreed that Gitlow had been wrong, they did agree that states cannot deny you, in this case, the freedom of speech. Now, what they did is they used the 14th Amendment as a vehicle, and that key vehicle is no state shall. Remember, the Fifth Amendment's due process clause did not say no state. It said the federal government, essentially, can't deny you life, liberty, or property, and all that. And so the 14th Amendment is new in the sense that it has that word state in it, which allowed the Supreme Court to say, in fact, this one element, freedom of speech, applies to the states, meaning states cannot violate your freedom of speech. Now, incorporation, again, means to apply. Now, it would have been nice for AP students around the world to have one court case that said, okay, the entire Bill of Rights applies to the states. But the way the Supreme Court has done that, they've done that on a case-by-case basis. So, it's called selective incorporation. On page 163 in your textbook, there's a list of the incorporation process. And what we see is speech in Gitlow is the first, and then we get later freedom of the press, freedom of assembly, freedom of religion, the right to bear arms, no quartering of troops, and so on, down the Bill of Rights. Not all the Bill of Rights has been incorporated to the states yet. But what happens is they use a case-by-case. So when somebody felt, like in Neer versus Minnesota, felt that the state of Minnesota had violated his right to free press, he got into the courts, and the Supreme Court said, we're going to incorporate that right to freedom of press in the First Amendment to the states. So instead of total incorporation, where they just in one fell swoop with one decision, one precedent, they apply the entire Bill of Rights to the states, what the Supreme Court has done is they're doing it on a case-by-case selective incorporation basis. So one of the kind of analogies I like to use is that the 14th Amendment is a car. All right? There's wheels, all that. The 14th Amendment, but not the whole 14th Amendment. The 14th Amendment's due process clause is the vehicle in which the Supreme Court, now this is a trailer, and it's got the Bill of Rights in it. And what they're doing is, okay, speech, they incorporate it in Gitlow. Press, they incorporate it in Neer versus Minnesota, and so on. So the 14th Amendment's due process clause has the language and is therefore the vehicle or tool in which the courts can selectively incorporate the Bill of Rights to the states. So that's a federalism issue, right? Okay, and then so subsequently we've had a series of cases that have incorporated the Bill of Rights to the states. And I think all the Bill of Rights except the 3rd, the 7th, and the 10th, and the grand jury requirement of the Fifth Amendment have been incorporated. All right. Now, another word for incorporated is federalized. Another word for incorporated is nationalized, which meaning that those parts of the Bill of Rights apply to all state governments, meaning those states have to protect those rights or cannot violate those natural rights. And again, though, you still have to apply the balancing test of freedom versus order, which we will dive into more as the unit goes on. All right, now that little first part right there, 0 period, that's day 1 for you. For the rest, and the next part here is day 2. And so for the rest of you guys in 1st, 2nd, and 4th, this continues to be day 1. And we dive into those first rights. And so if we look, let's look at freedom of religion. All right? Now, freedom of religion has 2 clauses in the First Amendment. Okay? And by the way, you want to look at the First Amendment. There's a whole bunch in there. There's speech, there's press, there's assembly, there's petition, there's religion. All right? It's chock full of nice civil liberties for you. And so there's 2 clauses in the First Amendment relating to religion. And that is the Establishment Clause and the Free Exercise Clause. The Establishment Clause is very, very, very hotly contested as far as what it means. All right, the language is pretty straightforward. It says government will not will not respect the establishment of religion. Now, does that mean, as we see in your notes, the government should not allow any kind of religion between church and state? Or does it mean simply the government cannot recognize an official religion, and then there's all in between? All right, so you get there. There's the accommodationist view, which says some religion can be involved. There's the separationist view, which essentially, and this is where we get the famous Jefferson quote, again, which is not in the Constitution, and people think it is this wall of separation, this absolute separation between church, any kind of religion, and state. To the other endorsement views, which says, look, you should allow some religion, but maybe not just preferential treatment towards specific religions. And again, this is a slippery slope, meaning the court will consistently reach different conclusions of what the Establishment Clause meant. And we will dive into that a little bit more in class. But it's this idea of the separation of church and state. How high should that wall be? Should it be low? Should it be incredibly high and an absolute barrier? I think this country definitely has religion as an important or integral part of its foundation if we go all the way back. And so, but then as we get into more modern times, we get this idea of this separation of church and state. And so it's going to constantly be back and forth. One case that the Supreme Court tried to use create this perfect test to say, okay, we'll create this precedent in Lemon v. Kurtzman, and then we'll know that if it violates any one of these things we set in the precedent, it violates the Establishment Clause. And if you look at it, there's 3 elements to the Lemon test, which is established in Lemon v. Kurtzman. Does the law or action have a religious purpose? Does it advance or inhibit a specific religion? And then, is there excessive entanglement with government and religion? Now, the idea behind the Lemon test was that if the law, the action, violated any one of those 3 prongs to the Lemon test, the court was supposed to say, nope, this violated the Establishment Clause, therefore that action is not constitutional. I think most people would say that Lemon is not a perfect test, and there's a lot of gray in there that people want to definitely discuss more. Now, when you get into page 3, and you can see that there's a bunch of key rulings regarding the Establishment Clause. We have Everson v. Board, which said, or incorporated the Establishment Clause to the states. So just like we talked, because of the 14th Amendment's Due Process Clause, you get Everson v. Board, which incorporates, federalizes, or nationalizes the Establishment Clause to the states, which basically said no state can violate the Establishment Clause, not just the national government. Now you get Engel v. Vitale, which says there's no state-sponsored or recited prayer in school. All right, we have Abington v. Shemp, which says no devotional Bible reading in school. So For instance, in art history, we talk a lot about Christianity because it's historically important. That's not going to violate Abington v. Shemp because it's not devotional kind of discussion of a specific religion. We also get Epperson v. Arkansas, which says states cannot prohibit teaching of evolution in public school because it violated a religious belief. All right? Now, the idea behind the Establishment Clause is the framers had witnessed Europe after the Protestant Reformation destroy each other or kill each other in the name of which type of Christianity is the most correct one. We have Protestant countries and Catholic countries fighting violent wars. And so I think what the framers believed was that if they could deal with the political theological question and separate religion and government, then we wouldn't fight over it. But as you've probably seen, and you can see throughout this year, is that I don't think you can ever separate religion and government to create that solution that the framers maybe believed they were. That in your private world, you had religion. In the public world, we separated those specific favoring of certain religions. This is controversial. We will try to look at both sides of it to see what that separation is or how much separation there should be. There's a series of court cases that we'll look at in addition to these first ones to try to figure that out. All right. Now, the second part of the religious clauses in the Constitution is the free exercise. And what you got to think about is that's exercise. That's working out your ability to exercise your religion. Government cannot prohibit the free exercise of religion. However, again, we have the balancing test of freedom versus order. So, if you get into this, freedom of religion and the free exercise clause, it provides your ability to worship. Now, if we look on page 4 of your notes, what you see is belief is always allowed. But when we get into practice, that's when we get the balancing test applying. Because it's going to depend on what that practice is if government's going to allow it. All right? And so, if you look, we have on E in your notes, we have 4 kind of numbers here that talk about the old standard for whether or not something violated the free exercise clause. Generally what it meant is government could not deny religious expression unless there was a compelling purpose for it to do so. Therefore, if a state wanted to limit your free exercise, they must have a compelling purpose to do so. And this sided on the side, or this leaned towards the side of protecting freedom to exercise your religion. Now, what we get is, and that generally ruled until about 1990, when we get a case called Oregon versus Smith. And what we had in Oregon v. Smith is you had 2 Native American gentlemen who were ingesting peyote, a hallucinogenic drug, for religious ritual. Now, they also happened to work for the state of Oregon and got drug tested, and what that did is they failed the drug test, and the state of Oregon fired them. And they said that this action violated the free exercise clause of the First Amendment because this was a religious ritual. And what happened is the Supreme Court basically said, yeah, the state of Oregon can fire these people. They had a compelling purpose to do so. And so what this did is this kind of set a precedent which enabled states to maybe limit the free exercise of religion a little bit easier. Now, generally in America, like I said before, religion is incredibly important on all sides. And therefore, you had a legislative response, which is called the Religious Freedom Restoration Act, RFRA, where we had liberals and conservatives kind of come together and pass this legislation that legislatively tried to go over that Supreme Court decision in Oregon v. Smith. And what that did is it basically tried to say, you need an incredibly compelling purpose to limit religion and kind of trump that precedent set in Oregon v. Smith, which made it easier for states to limit the exercise of religion. All right? And now again, like any legislation, we get this, somebody sues. And we get a new court case, City of Bourne versus Flores, in which basically states felt that RFRA violated states' rights, that they had this ability to do it. And therefore, what you get in City of Bourne v. Flores is the Supreme Court struck down RFRA And then what that basically does is that restores the precedent of Oregon v. Smith, which they were trying to get over or around with RFRA, and that restored the compelling purpose, making it, or they restored the precedent set in Oregon, which basically said that states didn't need a compelling purpose to limit religion. Therefore, making it easier for states to limit religion if they felt that they had a good reason to do so. But again, prior to Oregon v. Smith, and what RFRA tried to do was to make it incredibly difficult for the government to limit your free exercise. Now, you have a series of cases here that talk about certain religious activities that have been limited. Reynolds v. U.S. said polygamy was not okay. U.S. versus Lee said that Amish people could not pay, refuse to pay Social Security taxes for religious purposes. Now, what's kind of interesting is look at these ones that have been permitted. Jehovah's Witness kids don't have to salute the flag in school for religious cases. Wisconsin v. Yoder said that Amish kids do not have to attend school past the 8th grade for religious purposes. We also had, in number 3, the city of